Welcome to CARICOMP Insider, where high-tech facial recognition meets real-world intelligence.
"26 states have passed laws targeting deepfakes in elections. Not one federal law bans a deepfake political ad. And California's attempt to pass one? A court struck it down on First Amendment grounds. That gap between state action and federal silence isn't just a policy debate. It's already changing what counts as evidence in court and what doesn't. If you've ever been identified by a photo, verified your identity online, or even shared a video you assumed was real, this story touches you. Right now, more than 1,000 AI-related bills are moving through all 50 state legislatures. They cover biometric data, algorithmic transparency, hiring tools, criminal justice, education, and they don't agree with each other. A facial comparison result that holds up in one state can be challenged on completely different grounds in the state next door. The question running through all of this: when the rules keep shifting beneath your feet, how does anyone, investigator, attorney, or ordinary person, trust that digital evidence is what it claims to be? Louisiana passed a law called HB 178 that took effect August 1, 2025. It became the first statewide framework requiring attorneys to exercise what the statute calls reasonable diligence to verify that evidence is authentic before they can even offer it in court. That sounds straightforward, but it shifted something fundamental. Before, you could present a piece of digital evidence and let the other side challenge it. Now in Louisiana, the person offering the evidence carries the burden of proving it's legitimate up front. For anyone who's ever been on the receiving end of a false accusation or a misleading video, that distinction matters. It means someone has to vouch for what they're showing a judge before the judge ever sees it. At the federal level, an advisory committee proposed a brand new rule, Rule 707, specifically designed to govern machine-generated evidence. The final vote on that proposal is scheduled for May 7, 2026. Even if it passes, it wouldn't take effect until December of 2027 at the earliest. So for the next year and a half, federal courts will keep relying on the existing standard Rule 901, which experts increasingly view as too low a bar for the age of synthetic media. That's a long window where deepfake evidence could enter courtrooms under rules that were written before the technology existed. And it's not just courtrooms. It means the viral clip you see shared 1 million times during election season might never face any formal test of whether it's real. The 26 states that did act, their laws don't line up. Roughly half the country now has some kind of rule about deepfakes in campaigns, but many of those laws only require disclosure, a label saying an ad was made with AI. According to CNN reporting, one state's law only kicks in 30 days before an election. 30 days. A deepfake ad could run for months, shaping opinion, and only face legal scrutiny in the final stretch. For someone running a facial comparison or verifying a piece of digital evidence, this patchwork creates a practical nightmare. Your methodology might satisfy Louisiana's authentication requirements, but fall short of what New York or California demands. And for the rest of us, it means the protections you have depend entirely on your zip code. Meanwhile, a coalition of 40 state attorneys general from both parties warned Congress that pushing a federal moratorium on state AI laws would gut their ability to go after deepfake scams and AI-generated child exploitation. On the other side, preemption advocates argue that 50 different rule sets will slow American companies and hand an advantage to competitors overseas. Both sides have a point. But the people caught in the middle, investigators building cases, attorneys preparing for trial, and everyday people trying to figure out what's real, don't get to wait for the debate to resolve. They're operating in the gap right now. The biggest threat to digital evidence in 2026 isn't a better deepfake. It's the fact that the legal system can't agree on what makes evidence trustworthy, and that disagreement is the exploit. A defense attorney doesn't need to prove a video is fake. They just need to show the rules for proving it's real are inconsistent. So, synthetic media is outpacing the rules meant to govern it. States are writing their own playbooks, and those playbooks contradict each other. Federal fixes are years away, and until they arrive, the burden of proving evidence is real falls on the people presenting it in court and in life. Whether you're building a case or just deciding whether to believe a video in your feed, the question is the same. Can you defend why you trust what you're looking at? The written version goes deeper. Links below.
Now you know something most people in this industry don't. Use it. And when you're ready to put it to work, caracomp.com. We'll see you tomorrow.